Alright, in this video we're going to just take a look at page 5, not chapter 5, page 5 of the real estate purchase contract. So the first thing you'll see on here is section 16. 16.1 is default by the buyer. If the buyer defaults, the seller has these following options. They can either cancel the contract and retain the earnest money as liquidated damages, maintain the earnest money deposits, and sue the buyer to specifically enforce, or they can keep the earnest money on deposit and then check out other options according to what their attorney would give them. On the seller, it's essentially the same kind of thing. If the seller defaults, the buyer would get back their earnest money plus an amount equal to that. The buyer could leave the money in deposit as the earnest money and then sue the seller to try to enforce the contract, or they can accept the return of the earnest money and then sue the seller still. Section 17 says in the event they do end up in court, the prevailing party is entitled to reasonable attorney's fees. Section 18 says that any notices given, so this one's a pretty important one, any notices that are given have to be in writing, signed by the party giving notice, and received by the buyer or seller or their agent or the brokerage that represents the buyer or seller. And that has to happen no later than the applicable deadline in the real estate purchase contract. So important to remember, anytime you're giving notice, it has to be in writing, signed by the party giving notice, received by the buyer or seller, their agent, or the brokerage firm. 19 says you can't just automatically assign the contract without permission, so you'd have to get an agreement between both the buyer and seller before assigning. Section 20 says that the insurance and risk of loss. So as of closing, the buyer is responsible to get insurance covering the property. Risk of loss. So prior to closing, if the property were damaged by fire or any of those type of things, what you would need to do is take a look at first figuring out, is it more than 10%? Because if it's more than 10% of the purchase price, then either the buyer or seller could just cancel and the buyer gets the earnest money back. If it's less than that, then the seller is still responsible. Time is of the essence. This one's saying that any of the deadlines on this contract have to be met by 5 p.m. Mountain Time on the date stated, and it also says the term days and calendar days shall mean calendar days and shall be counted beginning on the day following the event that triggers that. So we'll talk more about that in another class, but important to remember 5 p.m. Electronic transmission and counterparts, we're agreeing that we can sign this via email, fax, anything that we need to do electronically with it, and we can also do them in counterparts. Acceptance is saying that acceptance only occurs when all the followings happen. So this is important as well to remember. Seller and buyer have signed the offer or the counter offer and noted to indicate their acceptance, and the seller or the buyer has or their agent has communicated it to the other party or their agent that it's been signed. So again, acceptance only takes place when it's been signed and checked as acceptance and then communicated to the party or their agent. And then your client would need to initial and date the bottom of the page.